To answer this question, I will come to my second.
देखिए एक आदमी ने एक रोपा में चेंज हुआ कि जी ग्रेजुएट होना चाहिए, एक ग्रेजुएट नहीं उसने दरख्वास्त फाइल कर दी, वो मेट्रिकुलेट है, नेचुरली ही विल बी डिस्क्वालिफाइड। अगले इलेक्शन में ये कंडीशन है ही नहीं, तो ही कांट बी अ लाइफ टाइम बार, इट्स इलॉजिकल।
That's what I'm saying. Article 62 may, if there is a declaration that person is not honest. Why he was not honest? Because in my case,
now you've taken a leap of faith.
No, my lord.
No. लेकिन अब आ जाती बात ये leap of faith वाली. So you are saying honest. Now honest. Suppose okay, let's take another case. Make it simple. He honestly declares in his nomination papers that he's a matriculate. He honestly declares in his paper that he's 16 years of age. Honestly, उसने लिखा 16 साल का हूँ. Consequence तो वही होगा ना.
If he is not 16 years of age,
भाई वो कह रहा है मैं हूँ 16 साल का.
If he is not 16 years of age and he is 14 years of age,
आप बात नहीं समझ रहे हैं ना. 25 साल का सिर्फ लड़ सकता है ना इलेक्शन. वो सचमुच कहता है मैं 16 साल का हूँ, वो सचमुच कहता है मैं ग्रेजुएट ना हूँ. आप इसको नेचुरली कांट कंटेस्ट इलेक्शन. सो ये जो ऑनेस्टी और डिसऑनेस्टी वाली बात तो बिकम्स इररेलेवेंट. इट्स अ फैक्चुअल डिटर्मिनेशन.
That's what I'm saying. Who has to do the factual determination?
चले ओके आगे बढ़े. मैं
Only election tribunal through recording of evidence.
We've understood the first point, please.
Now my
move on to the next point, please. The duration part.
इसी पे देखें ना, जो फर्स्ट आपने कहा कि प्री इलेक्शन जो उसकी नॉमिनेशन पेपर की रिजेक्शन है, that does not cover the grounds mentioned in 68. वो तो होने ही आफ्टर द इलेक्शन है.
After the election.
तो इसलिए वो तो जस्ट रिजेक्शन ऑफ द पेपर्स. That's for your arguments.
That is my argument.
कोई डिक्लेरेशन कोई फर्दर नहीं हो सकती.
वो क्वालिफाइड था या नहीं था पहली डेट के ऊपर, वो तो रिटर्निंग ऑफिसर ने चेक करना है ना. अगर रिजेक्ट होगा तो अपील हो जाएगी, अगर कोई अपोज करेगा तो भी अपील हो जाएगी. ठीक है ना. मगर बात क्वेश्चन इज दिस कि आफ्टर सेवरल इयर्स वो कहेंगे इवन एट द टाइम ऑफ फाइलिंग योर नॉमिनेशन पेपर यू वर डिस्क्वालिफाइड. दैट डिक्लेरेशन इज टू बी गिवन बाय विच कोर्ट?
Election tribunal.
Election tribunal.
Understood that, Mr. Forum. Let's proceed further.
एक बात इसमें और बता दें. इलेक्शन ट्रिब्यूनल क्या डिस्क्वालिफिकेशन 63 आर्टिकल 63 से हट कर दे सकती है? और अगर कोई डिक्लेरेशन वो कर दे कि इज डिस्क्वालिफाइड और वो डिस्क्वालिफिकेशन 63 में नहीं आता,
नहीं
क्या उसके बुनियाद पर
नहीं
फॉर इवन फॉर सिंगल डे ही कैन बी बार्ड फ्रॉम कंटेस्टिंग?
Election tribunal has to decide on the basis of 62 for qualification.
No,
and
disqualification is 63. This is clear. If any declaration is made by the tribunal which is not in accordance with Article 63, whether on that basis, even on the declaration of tribunal, somebody can be debarred from life or even for a day.
No, my lord. Without trial cannot.
Even trial is conducted, the tribunal come to the
even after trial it cannot.
वो कह देता है कि disqualified.
Without the ground given in 63 he cannot.
Mr. Forum, could we just summarize what's happened? Your submission is that first of all disqualification can only come through a plenary court of plenary jurisdiction plus the election tribunal and the appellate forum hearing that election tribunal's appeal. That's one. And declaration cannot come from any other source.
Change here.
मैं कुछ और कहना चाहता हूँ.
My lord.
So this we've understood. I'm just saying that the premises on which Samuel Baloch proceeds is that once that declaration is in the field, that you're disqualified.
My lord.
Unless that declaration is set aside, you remain disqualified.
My
That's
lord.
the premise of Samuel Baloch, number one. Number two, Samuel Baloch also says that declaration is not right in your face saying that you infer from the circumstances of the case. For example, वो कहेंगे कि आपने misdeclaration की है, इससे infer कर रहे हैं आप honest नहीं. Because nobody is directly इस पे तो evidence नहीं ना आप honest है, I mean आप infer कर रहे हैं. That's what Samuel Baloch also says. So you construct it, you say कि आपका form गलत था, आपका ये गलत था, इससे हम construct ये करते हैं कि आप अमीन नहीं हैं. These are the two premises on which Samuel Baloch proceeds. Now we just need to understand whether at all the fact that the disqualification stands can continue forever, and if that disqualification was taken into a criminal proceedings and he went through 63H and went through a actual conviction, he comes back and there are a number of other offences where he commits even a heinous crime, he comes back. तो बस इसका हमें आप बताइए कि the fact that Samuel Baloch goes on the premise that declaration on the civil side done will continue as long as that declaration is set aside.
My Lord has properly rephrased Samuel Baloch, but my argument is a bit different from that.
Right.
My argument is any declaration coming from a high court in a constitutional jurisdiction.
We understood. That's not a declaration. So that's all those declarations are out.
The only court of plenary jurisdiction is elected.
Understood. आगे चले.
Now, the whole argument revolves around whether Article 62 and 63 are inherently same or distinct. If they are inherently same, they can be used interchangeably. Then we can interpret 62(1)(f) in view of 63(1)(h). But if they are distinct, then we cannot interpret these two. We cannot try to resolve the ambiguity. So I have to demonstrate that Article 62 is distinct than Article 63.
Is it not dependent? Article 62 is not dependent upon 63?
No, my lord. How do I demonstrate that? If I just go to Article 62, it says, a person shall not be qualified to be elected or chosen as a member of Majlis Shura unless it talks about an event prior to the election.
Yes. Yesterday.
My lord, 63.
I don't see much turning on your point, but shall I proceed with it?
A person shall be disqualified from being elected or chosen as and from being a member of Majlis Shura if in 63 after the election, after the he becomes member, the event, any of the event given in 63 can trigger and he can be disqualified. But in 62, after he has
election ki aap baat
no
kar rahe hain.
event subsequent to the nomination can disqualify him.
I don't agree with you, because if that is the case, then a non-citizen can contest elections, which is not provided for in 63, which is only provided for in 62. So I don't think this जो आपने distinction draw की है, I don't think anything turns on it.
My lord, 62.
It says he is a citizen of Pakistan. This provision is not found mentioned in 63. Suppose a non-citizen files in a nomination papers and somehow gets elected. So you mean to say that challenge cannot be made about him? I would not agree with that proposition.
My lord, because the entire section of 62 has to be read in view of the opening clause.
Particularly.
It says a person shall not be qualified to be elected or chosen.
कुछ शुरू ही तो नहीं था. ऐसे ही अमेरिका
आर्टिकल 65(1)(f) के तहत नाअहली की मुद्दत के तयन का मामला, बड़े केस की बड़ी समाअत अभी जारी है। जिन केसेस में शवाहिद रिकॉर्ड हुए वहां सुप्रीम कोर्ट डिक्लेरेशन दे सकती है, खुर्रम रजा ने कहा। फिर तो आप समीअल्लाह बलोच केस की हिमायत नहीं कर रहे। चीफ जस्टिस ने कहा, मैं एक हद तक ही इस केस की हिमायत कर रहा हूं, वकील ने बताया।
No, ये बात आपकी doesn't hold any water. Let's read first disqualification. He is a citizen of Pakistan. Suppose Mr. James Gray from America comes and contests, born American citizens, never been a Pakistani citizen, and gets elected. Please wait. Now go to 63(1)(c). He ceases to be a citizen of Pakistan. That is, a person was a citizen of Pakistan, has now taken on citizenship of America. So you are saying, yes, once that somehow Mr. James Gray got elected, you can't touch him now. Sorry to say, ये आप ऐसा distinction not draw करें.
I am not saying this.
Mr. Khurram, there's one way of looking at it. Just read the first line of 62 and the first line of 63. It will show to you that it's interchangeable. There is hardly any difference. A person shall not